for taking the time to come out this evening to talk about the labour law. It's always a topical issue, and I really hope we can get through as much as possible in the limited space of time. What I'll do is I'll go through the different sections, and if there are questions, it may be appropriate to ask them during that session, or you can wait because we have concentrated until the very end. Now, the guide that I have today is a comparison of the UAE and the DIFC law. I spoke to Alicia earlier, and she was unsure whether there are many who have a particular interest in the DIFC. So by show of hands, is there anyone who's actually based in the DIFC? Okay. So we have two people in the room. What I'll do is I will go through each slide and touch upon the DIFC differences, but with a focus predominantly on the labour law. A lot of the tips that I'm going to give today anyway are relevant whether you're in the DIFC or the UAE, and therefore it's really so that you can walk away with practical tips, because I'm sure you will. The point is, I would like you to walk away with more practical tips. So regardless of whether you're in the DIFC or mainland or in the free zone, hopefully the tips that you walk away should be beneficial. Okay, so yes, I'm Tainji McCann. I'm a senior associate at Taylor Westing. We offer a wide range of legal services, and I currently am in the employment department, and they often are asked to give talks of this nature. So I'll try to kind of focus on the main areas that are problematic. And I'm sure if you are in HR, you would know that there have recently been some new decrees that were announced within the month that will be effective from the 1st of January next year. So we will look at those towards the end and just see the changes that have been proposed by the Ministry of Labour, and see how they will affect basically your working practice as it is now. So how the materials now are basically drafted as the labour law is now, and at the end we'll look at the changes. Okay, so I think the best place to start off is really looking at the law. If you are under the UAE labour law, and you're governed by the Federal Law Number 8. Okay, so don't write lots of notes. Okay, so UAE labour law, and the free zones have their own rules and regulations. Those of you in JAFSA would probably have the most comprehensive rules and regulations. The DIFC is its own jurisdiction. So law number 5, 2004, it was amended by law in 2012. And the DIFC is a common law jurisdiction, so really based on common law principles as you would find, say, in other jurisdictions such as the UK. The DIFC is an independent jurisdiction. It has its own court and it has its own system. Outside in the UAE, onshore or in the free zones, you're under the labour law, so if there is a dispute, you will ultimately end up committed by courts. Most of the free zones, say for example TCOM, will have their own specialists where they are trained as mediators, and when there is a dispute, an employment dispute, the first step is to start the mediation, and then that will continue on to the actual Dubai courts. Just general rules for expatriates that I'm sure most of you are aware. Expatriates should really contribute to the UAE, should be sponsored, i.e. have a visa, should only work for their employer, and should leave the UAE if you're an expatriate, should leave when your contract is terminated and move on to another sponsor. So that's kind of general knowledge that I'm sure you're all familiar with. Okay. So under the UAE labour law, onshore registered law, employment contracts is registered with the Ministry of Labour, and with the DIFC, they don't actually keep records of the employment contract, but it's mandatory to have an employment contract filed with the DIFC, and that's the same with the free So if we look at, start off by really looking at the purpose of an employment contract, many HR managers ask me the question, why should we bother having a company employment contract? We have a standard contract. Most of you would already be familiar with the standard template that's in English and Arabic, and that's filed with the authority or the Ministry of Labour employment contract. And my response to that is, it is a recommendation to have a company contract. A company contract is one that should really be tailored to your business. So whatever your business is, if you're in technical services or in energy and oil and gas, it should be tailored to the purposes of your organization. So if what's important to your organization is, say, inventions, for example, it's really important that you have an employment contract that has an intellectual property clause. Or if you deal with events, that's quite common. And what might be important to your organization is your clients' details. So that's why it's really important to, yes, have the standard employment contract, but also one that is more tailored to the business. And in my experience, the standard contract is not really adequate, simply because it's really a matter of filling in the gaps. And those of you...
Sorry.
Okay, take a seat. Those of you who are under the Ministry of Labour may also be aware that at the back of the Ministry of Labour contract, there is a section called Other Conditions. Sometimes you're able to input restrictions there. I think it lets you type in 10 or 12 words. I can't remember what the count is, but it's really kind of basic. But I still do say that if you're under the Ministry of Labour, use those special conditions to tie it up with the company contract, so that if there is a dispute in the future for whatever reason, one contract will have to be read with the other contract. So that's just a practical tip if you're under the Ministry of Labour. DMCC, those of you in the DMCC, I have come across contracts where they will allow the free zone contract to be pasted as an appendix to the free zone contract. That's also useful. That gives you the opportunity to tailor your employment contract to your organization. But on this slide, you'll just see the purposes of a company contract. So it's a legal requirement. You agree terms and conditions at the start of the relationship. When there's a dispute, that's the first thing that we go to. So whenever I have a client who has a dispute with an employee, the first thing I ask for is the employment contract, so I can look and see exactly what has been agreed between the parties. Stability of workforce, if you want to have restrictions, that's where you put it. If a company is making major investment in, say, a senior executive, paying them lots of money to come out, shipping costs, whatever the investment, it's important to have an employment contract that can restrict. So, for example, one strategy is to say, okay, so we're spending so much money bringing this person over to the UAE, let's have a limited contract, at least for 1 year or 2 years, so we can at least get our investment back, rather than having them come over on an unlimited contract and within 6 months they're off. So it's a useful tool. Obviously, you don't want to restrain somebody who clearly doesn't want to be there, but giving the individual an incentive to stay, and sometimes a limited contract is a good mechanism to do so. You have flexibility on longer probation if you have a company contract, but the maximum under the UAE labour law, as I'm sure most of you are aware, is 6 months. Under the DIFC, everything is fairly contractual. You're able to, the parties are able to make a decision in that respect. Notice periods as well, and it gives you an opportunity to say, currently, before the resolutions, it was not uncommon to see 6 months notice for high-level executives. Now, it may be a lot more difficult given the changes, simply because they said the notice period shouldn't be longer than 3 months, but we'll look at that in the end. But it protects the business, trade secrets, intellectual property, and confidential information. Is there anything else somebody wants to raise on company contracts? Any questions? So in the UAE, there's two types of contracts. Limited contracts, which is a contract with a clear start date and a termination date. And then you have the unlimited contract, which basically means you have a clear start date and so the party will just give notice. Under the UAE, which we've touched upon, most employees will have two contracts, the DL and the company contract. In the DIFC, it's usually just the one contract, and there's no standard form. Okay, yeah, so we touched upon the probation period, maximum 6 months. During the probation period, anyone can give notice can terminate the contract without notice. During the probation period, you're not actually allowed as an employee to take sick leave or annual leave. But in terms of practicalities, we always say that as an employee, you need to have your own elements of reasonableness. I think what HR managers need to take into consideration is that the labour law is the bare minimum. So whatever you give over and above the labour law is fine. So it's not uncommon for a company to let an employee take leave if there's a wedding or whatever during the probation period. It's just that element of trust and confidence between the parties. The DIFC has no regulations about probation period. It all needs to be agreed contractually. Okay. So working hours is something that I get asked about. So the labour law general guidance is 8 hours a day or 48 hours per week. That's usually if you're on a 6-day week. On a 5-day week, it's 40 hours. Overtime should be a maximum of 2 hours per day, and there's an uplift of 25%. 50% if the employee is asked to work on a Friday, but they shouldn't be asked more than twice. Managers and supervisory staff are not actually entitled to overtime. So then I get asked the question, how do you classify a senior staff or a supervisor? We've looked at the approach of the court, and the court have basically said anybody who has authority over another individual within the workplace can be viewed as a supervisor. So if it became a contentious issue, they would actually look at the responsibilities of the individual. Did they have control over somebody? What is their job description? I think it's Article 72, there is no overtime if you're in a position of authority. So in terms of practical tips, I came across an incident where there were some employees basically claiming overtime simply because they were sitting in the office at the end of the day. And that really doesn't qualify for overtime. Overtime, there needs to be a request from the employee. I need you to stay extra to complete X amount of work or whatever. Employee should really record it, and so should the employer, that there needs to be a request for this overtime. If it's simply an employee is just taking their sweet time to do their work, and instead of leaving at 5 o'clock, leaves at 8 o'clock, then it's a bit unfair for them to claim overtime. So there should actually be that request and the requirement, the business need for the overtime for that to then be paid. And in the DIFC, again, it's 48 hours for a 7-day period. Most of the organizations I've come across in the DIFC, especially in the financial services arena, will ask their employees to opt out of that 48-hour restriction, and that's not uncommon in other jurisdictions as well. So it's normally with the employment contract, you can only take over 48 hours and things like that. And the DIFC is contractual, so take over. Okay. Ramadan hours. Under the UAE labour law, the reduction is 2 hours, as I'm sure most of you are aware. And we get asked the question whether that is just applicable to fasting employees, whether that's applicable to everybody. The UAE, the Ministry of Labour has been quite clear that everyone is entitled to a reduction of hours during that period. Practical tips, we suggest that you consider shifts, getting people in early, getting people in later, doing whatever you need to do to keep your employees at work, but reducing the work time. We have come across every year in the reports of the press, if you Google it, several employers who get fined because they are not abiding by the Ramadan hours. The DIFC, the normal working hours are reduced, but that's only restricted to Muslim employees. So that's one of the major distinctions of the UAE and the DIFC.
So with working hours, on the previous slide we were talking about 40 hours for Friday, 48.
Yeah.
That's working hours.
Yeah.
Not hours of work.
Yeah, it's working hours.
So it doesn't count lunch breaks.
No. It's not. It's actually working hours. So if your working hours are 8, then your working hours will be 6. Shift seems to be the way around it, getting people to start 2 hours later, and then getting other people. It depends on the nature of the business, but I've seen all sorts of methods to ensure that work doesn't stop. I think if there's a crisis at work, then it is reasonable to request employees to stay longer. But priority for employees who leave should always be the employees that are fasting to avoid the company getting into any sort of trouble. So annual leave, we've got the 30 calendar days per annum. It is, many companies would prefer to use working days, which is also acceptable. The equivalent of that is 22 working days. So it's up to how your business prefers to operate. The 30 calendar days obviously includes weekends, which in some instances organizations would prefer to use calendar days, so it's reduced to 22. When an employee leaves, they need to be paid whatever they've accrued at the time. And one of the useful provisions that I've come across in employment contracts is to say that when you're in your notice, if we put you and place you on garden leave, that you utilize your annual leave. And that way, garden leave is, just to explain, it's where an employee is on notice and asked no longer to attend the office. They're placed on garden leave for the duration of their notice, for whatever reason. Sometimes if there has been a breakdown of trust between the employer and employee, the employee is asked to step away during the garden leave. And it's useful to have in the employment contract during the garden leave, you will use your annual leave. And that way, at the end of the employment, you wouldn't have to, well, depending on how much holiday they have left, but you wouldn't have to make a payout. We have 10 days currently in the labour law, but there is the new annual holiday, the Martyrs' Day, that's coming up. I'm unsure, they said it will be an annual holiday. I'm unsure whether it will fall on the same day every year, but that's an additional public holiday. In the DIFC, fairly similar, 21 days per annum. Can only take if the employees worked at least 90 days. In the DIFC, you are allowed to carry forward 20 days, which is quite substantial, and for some reason in the DIFC, quite normal. Under the UAE labour law, they do say that there's a preference for the employee to use their holiday in that year. They can carry the holiday forward for an extra year, but after that, the employee won't have the right to claim back. So the holiday can only be carried over to the next year, and after that, there is no further entitlement to the holiday. And by the same token, if the company refuses to give the employee holiday for whatever reason, say business reason in that year, year, they have to be given the option to utilize their annual leave. So practical tips is have a holiday policy. I know it sounds simple and basic, but you'd be surprised how many organizations don't have that. Holiday forms, a schedule that they should request holiday in time, and have it dealt with as well in the employment contract.
What is the significance of garden leave?
About the notice, whether or not the employee gets their notice. So the labour law says that you cannot reduce notice. So if an employee, as long as the employer is going to pay the employee to be off on garden leave, then the court is fine with it. An employer is also able to pay an employee compensation in lieu of notice. What's important, which basically means you're not going to have your notice, your termination date is now, and we'll pay you for your notice. The court is also fine with that, as long as compensation is paid. So if a company, for whatever reason, takes the decision to place the employee on garden leave, that's absolutely fine. It's not frowned upon. What's important is that the employee is paid.
But in that case, employee is incurring a financial loss. Compare an employee who's not on garden leave and the other employee who is on garden leave.
Okay. What loss? Sorry.
So in the sense, you will equate the annual leave quota of that individual
You mean
for that.
compensation?
Yeah.
Okay.
And
so that's not garden leave. So if you're on garden leave, you don't really have a loss, because even in that month you will still accrue, say, the 2 days annual leave. Where you could potentially have a loss, what you're talking about is where we say your termination date is today, and we'll pay you for compensation in lieu of notice. There's potentially a loss. What most employees, if I'm advising the employee, I will always try and negotiate that the employee is compensated for that month or 3 months, if that's the equivalent of the notice. The labour law does say where an employee does not get their notice, then they need to be compensated. So it's within their right to be compensated.
I think I lost the piece of information. If the employee is not using the annual leave, can these days be brought over to the next day? Can they be accumulated
To the next year?
Yeah. The maximum number of days.
Is that DIFC or just
Really labour law.
Okay. So the labour law says you can, but just for 1 year. So for the next year. I mean, they would prefer that an employee, basically the labour law says an employer is able to state when the employee takes their holiday. So if it's for no commercial sense or no business sense for the employee to take their holiday, then effectively, yes, they can carry it over. But you can't extend that over the second year.
Is the employer obliged to pay for the air passage during the annual leave?
For the?
Annual leave, during the annual leave.
Yeah, you mean salary?
No, the air passage, the air ticket to the...
Oh, okay. So that will depend on your contract. That's another, if you like, misconception that the holiday ticket is in the labour law. It's not in the. I think that was probably one of the first questions. I paged through the whole of the labour law looking for that, because actually when I first got here, thought it was part of the law. It's custom and practice because it's an expatriate community and everyone's away from home, so it's something that's developed over time. But believe it or not, it's actually not under the labour law. It will be, if it's an employment contract and the employment contract says once a year you get a ticket, then yeah, then it needs to be paid. The repatriation ticket is different, the one at the end, but the annual leave ticket is contractual.
Go ahead.
We'll do two.
2 questions, one on
Okay.
30 calendar days is the annual leave, but I've seen companies that give 22 working days.
Yeah.
Now, at end of service settlement,
Yeah.
you pay only for 22 days, right?
Yeah. Yeah. If you do working days, then
So your
yeah.
settlement also
Yeah.
22 days. My second second question is on leave. Is it possible for you to put it in your house rules or your company policy that beyond a certain number, which is 60 days, your leave will not be accrued?
Yeah, absolutely. It really shouldn't go over 2 years anyway. So, you shouldn't have a situation where an employee's got like 120 days. It really should be maximum.
Thank you.
Sorry, I've got 2 questions. One is about if I terminate an employee today, and by giving him the notice pay for 1 month or 2 months, depending on the contract,
Yeah.
should I calculate the number of leaves that he's entitled for during the notice period while I'm settling him? Should I?
Yeah.
Is that by law?
Well, the law,
Like if my notice period is 1 month.
the law says you need to compensate the employee for the notice. It doesn't break it down, but
I'm talking about the leave
Yeah.
entitlement for the notice period.
yeah, they need to be paid
So
once
if it's
approved.
2 days per month, so I have to pay
Then
him
you
that
do
2
your
days.
calculation.
All right. And is the notice payable on basic salary alone or basic plus other allowances?
Notice is your full salary.
But I understand that the law is different in Abu Dhabi and Dubai. I'll tell you what, because I had a case.
It's the federal law, so the federal law is applicable everywhere.
When you-
But the courts, the Abu Dhabi courts and the Dubai courts interpret the law differently.
Differently, because I had a case very recently where I had to pay an employee
Yeah,
on the notice pay.
yeah,
And the Dubai law says that you pay only on the basic.
yeah.
The Abu Dhabi law says that no, you pay on the basic plus other allowances.
I've come across that situation many times. It's the interpretation of the court's interpretation.
Right.
There's no law of precedent.
But then
there's no law.
it's not there in anywhere in the federal law. You can't find that out.
No, it's not broken down in the manner that you're asking, but it says that you need to be compensated. But you're right. The law is the same. It's federal law. But the way the courts and the different federal courts interpret the law is different. And there's no law of precedent. Basically, what that means is what one court says, the other court can make its own finding. So that's a difficulty we have as lawyers. But we always like to advise best practice, and that's why I'm here today. Whatever I advise you would be best practice principles.
And the annual leave is paid on basic and housing or the gross, or is it on the gross salary? Annual leave.
And the labour law actually says it basic and housing, takes away transportation. But practice, in my experience, there are no deductions. If you want to go to the letter of the law, you can make that deduction.
Yes, you mentioned earlier that within the UAE labour law, unused 22 calendar days,
Yeah.
that it was admissible. Just reference to the UAE labour law. I've had experience that if the situation goes to the courts, they do not accept the 22 working days, and therefore
They reverse
force everything back to the 30 days, which creates a lot of confusion. So, do you have a comment on that, or maybe advise people maybe to stay clear of the 22 working days?
Most of the companies that go 22 working days, it's normally their practice and their preference not to consider the weekends. But you're absolutely right. When it goes to court, they will revert back to what the labour law says, letter and code. But our kind of guidance is 22 working days, so you would say the truth at that rate per month, and that should be the calculation. You might be off, but it's just a judgment call. If the company wants to stay with 30 working days, it's within their rights to do so.
But doesn't the law says that if holiday falls in between the leave, it's part of the leave?
Yeah. Yeah.
It's
So the
not
question
considered.
that he's asking is, if there is a person who's taken annual leave, and you have, for example, a public holiday that falls in between that leave, then the employer uses that under the labour law. But for instance, in the DIFC, where everything is working days, or if the company's taken the decision to use working days, then no, then the employee won't lose it. And that's why there's this general shift towards working days.
What is the legal justification for this?
Pardon?
What is the legal justification?
There is no legal justification, it's just a formula, and the formula is 30 working days is equivalent to 22 working days. And it's not in the labour law. The labour law says 30 working days, but companies want to move away from it. They would rather use working days. So, and that's what we would say is the equivalent.
Even if you include the weekends, it's coming less than 30, right?
If you include the weekends, it would be 30, but if you just count the working days, it
No,
would
what I'm
be...
saying is if you suffix and prefix the weekends on a 22 working day,
Yeah.
still you're going to lose.
Yeah, probably. Yeah, but in my experience, employees prefer the working days for obvious reasons. Okay, so I'll just move on from that. Okay, so we're just going to take a quick look at sick leave. Under the labour law, it's 90 days ban sick leave before you can terminate an employee. So that's 15 days full pay, and 30 days half pay, and the other 45 days is with no pay at all. And after that time, the employee can be terminated on the grounds of sickness. There's no entitlement during the probation period to sick leave. Obviously, we would say again, best practice use reasonableness in those circumstances. 3 months after the probation period, only after 3 months after the probation period are they entitled to sick leave. If an employee is found for some random reason working for another employer and is supposed to be sick, then you can terminate without notice. The DIFC is 60 working days, no entitlement to sick leave in the DIFC if the employment service is less than 1 month. And again, if the employee has taken 60 working days, then they can be terminated again without notice. I think one of the points to think about when you're terminating someone on the grounds of sick leave is whether the sickness is caused because of an occupational hazard. So if it's a work-related sickness or illness, then it needs to be treated differently. So for work-related, I mean, I haven't really covered it today, but just so you know, for work-related occupational sickness or accidents, if you like, it would be 6 months full pay and 6 months half pay. So that needs to be taken into consideration. Again, under the DIFC, if the sickness is a disability, there is the potential for the employee to say, I've been discriminated on the grounds of my disability, because there is disability discrimination in the DIFC. So it's really important prior to a termination on the account of sickness to really investigate as to the reason the employee is unable to attend work. Okay, so maternity leave is still at 45 days, and despite all the kind of efforts to increase maternity leave out in the UAE, so it's 45 calendar days. That includes periods before and after the delivery. Under the UAE labour law, an employer can have an additional 100 days, but it needs to be for pregnancy-related illness. So the illness must be related to the pregnancy and obviously needs to be signed off with a medical certificate. If the employee has only worked less than a year, then they'll receive half pay for, but the period will be the same. Also, which is not on the slide, when the employee comes back to work, they're entitled for 18 months to breastfeeding nursing hours, which is an hour a day. They say 2 30-minute periods. I think most employees either says off you go an hour early, or take long lunch, or come in a bit later. So it's up to what we recommend that the employee and the company come to some arrangement. The DIFC is a lot longer than that.
I had an interesting one on that recently. My personal, even if the lady is not actually breastfeeding, nursing, is the entitlement still there? Because there was an example where someone wasn't actually, was just taking the time and is the entitlement for any pregnant woman, or does there have to be?
I think the labour
how
law.
do you prove it?
I think the labour law assumes is making the assumption that all female employees are nursing their children. I haven't come across an example of a company asking their employee to prove it.
I think it was a question of the employee making it obvious that they
Oh,
weren't.
well, I
they
think-
were taking the car.
I think if it becomes obvious, then it's something that can be certainly brought up if you have sufficient evidence to say you're just going shopping for that hour or taking an extended lunch.
I think there was an assumption that it was an entitlement
Yeah.
rather than,
No, it really is there for that specific purpose, and if you have good reason to believe that the employee is not utilising it for that purpose, then I suppose it can be something that's brought into question. And if needs be, you can take any aspect of it. But yeah, it's for that purpose, for nursing.
But it should be actually for any sort of feeding. It may not necessarily be. I mean, maybe.
For bonding, baby.
No, not exactly the bonding. Maybe even a bottle feed should also be considered that way, because that also takes time.
Well, look, the labour law was written a while ago, and basically everything that's been written has a lot of assumptions. So we have to basically go with what we've got. Obviously, as the employer, you should use reason, and that's what we always advocate. Use reason, use common sense, and work with the employee in that sense. But the employee can say, I'm going to nurse, and there's not really much you can do about that. DIFC, 65 working days, 33 days full pay, 32 half pay. The interesting thing about the DIFC is it's expressly stated that the employee has the right to come back to work, and also really should have the same level of seniority. DIFC is a little bit more advanced in terms of common law principles. So there are potentially discrimination claims where an employer doesn't consider or for instance fills their slot with somebody else's job in the DIFC, more caution has to be taken. Okay, so notice period minimum 30 days, has to be in writing, and I think we've discussed that you can pay in lieu of notice. You cannot actually reduce the period even by mutual agreement, so there still needs to be that compensation paid. The DIFC, if for any reason it's not actually written in the employment contract what the notice period is, then depending on service, 1 and 3 months will be 7 days, 3 months and 5 years, 30 days, and more than 5 years will be 90 days. But the point to remember about the DIFC is everything is contractual. So you can actually agree to waive the notice if you like, whereas you can't actually do that in the DIFC. And under the UAE law. Yes.
Do you have notice period longer than 30 days?
Yes, absolutely. Yeah.
Will you be able to enforce it?
Yes, absolutely. From next year. From next year. Currently, a notice is, I think the maximum I've come across is 6 months. The new decrees have changed that to 3 months, but as it currently stands, you can have a longer notice period. And that's normally for a senior executive or someone on the trade license. So you know how long it takes to take someone off the trade license off the bank, you have to take them off the signatory. That process in itself takes about 3 months.
It's on free zone. Jobs on free zone. Everything on jobs on free zone follows you.
That's what they say.
Okay, so the point to note about a limited
It's a federal loan.
there's not actually supposed to be a notice. So a limited contract is from this date to this date, and at that date, the contract comes to an end. What you should have in a proper limited contract is something called a renewal clause, which basically means 30 days before this date, the parties will tell each other whether they're going to renew. That's a limited contract. It's not actually notice. Basically, you can come to the last day and walk out and say, bye, come off, and you haven't actually breached your contract. But what the contract has is a renewal clause in there. So are we going to renew on the same terms, or are we going to terminate? What are we doing? Or under the UAE labour law, when you're on a limited contract, if that date comes to an end and the parties just continue to work, it automatically changes to an unlimited contract. So that's the major difference.
The new decree says that we can get out of it.
We'll deal with that. We'll deal with that at the end. But so far, I'm just dealing with the current position. So the current position is a limited contract with a clear start date. And the new decrees are trying to make everything a bit more flexible for employees in particular.
On the same question, if somebody does not give you a notice in a limited contract, he can just walk out.
He can walk away. And that's the difficulty that a lot of employers don't get, if you like. A limited contract means it starts on this date, expires on this date. If maybe he works beyond it, then you could argue that it's now an unlimited contract. But if you actually say, right, I'm taking my bag, bye, I'm done, you're not actually in breach of contract. It's expired, it's come to an end. Nobody's given any indication that their limited contract is going to continue. When you terminate a limited contract, now that we're on the subject, early, it has an impact on end-of-service gratuity. So if you're on a limited contract and the employee breaches the contract, then potentially the employee gets no gratuity, which for some employees is a hard pill to swallow, particularly if the employee's been working for, say, 4 years. But after the 5-year period, then the employee will get the gratuity stays. But between 1 and 5 years, if they breach that limited term, then there's no end-of-service gratuity. So that's really quite important. And by the same token, if an employer terminates an employee during the limited term, then there's compensation payable, which is 3 months compensation for whatever's left on the contract. So if it's 2 months left, then it will be 2 months left on the contract. If an employee is the one who breaches the limited contract, then the employee is liable to pay 45 days to the employer for early termination of a contract. So that's quite important when we're looking at limited and unlimited contracts.
Can you please repeat this? I just missed. So you were saying that when in between, if a limited contract is terminated by the employer, then the employer is supposed to pay 3 months plus the balance period of the contract. Is that what you're saying?
No. So 3
Total.
months or whatever's left on the contract, whichever is smaller. So if it's 2 months, for example, then the compensation will be only 2 months. But say it's a year, then the maximum will be 3 months.
Okay.
But if it's the employee breaching it, then it's 45 days, so it's basically half of that, so a month and a half. Or whatever's left on the contract, if the period is less than 45 days. Okay, so currently, and I've put kind of asterisk there because this has recently been changed. So on a limited contract, the maximum is 4 years. Can renew on similar or shorter periods. We spoke about early termination compensation, and ESG will only be payable if the employer has worked over 5 years. I think we've actually spoken about this. If not renewed, the parties will be on an unlimited contract. So we'll look at the changes towards the end. Okay, so we're just going to touch upon summary termination. This is termination, sorry.
That 4 years, is that in federal law number, right?
It
Or has
is.
it been an addition afterwards?
No, it's actually in the law. Yeah, 4 years. That's a nice one. Okay, so summary dismissal. That's basically where somebody's being terminated on the grounds of misconduct under Article 120. So we'll look at Article 120 at the moment. But when an employee is terminated for Article 120, basically their termination date is today, they're paid up to today, and they don't actually receive any end-of-service gratuity because of the misconduct. What's really important to take away from this list is that the list is very restrictive. And unlike in the DIFC, where the text is, would a reasonable employer have terminated in the same circumstances? So in the DIFC, if someone has, I don't know, stolen something and an employee has said yes and has done an investigation, then that's probably sufficient for a termination. But those same set of circumstances under the UAE federal law wouldn't apply, because the federal law says it needs to be a conviction. So it goes that step further. So many times I have an HR manager saying, oh, it's really obvious, this is what's happened, can we not terminate for cause? No, not unless it fits squarely under the UAE labour law. Otherwise you might find yourself going through litigation and paying through compensation. So it's really important, if you are going to terminate someone under Article 120, that the circumstances fit squarely within the list. Otherwise, any other summary will be deemed as arbitrary termination, which is 3 months compensation. An employee is also able to terminate where the employer has breached the contract, and that's usually when they haven't been paid for whatever reason, or we hope not, but the employee has been assaulted by the employee. So, like I said, the DIFC is more objective. It's an objective test. Would another employer terminate in these circumstances? If the answer is yes, then it would be justified. So we're just going to take a look. Oh, sorry. Yes.
If you terminate an employee as per Article 120, which very clearly says that you can terminate without notice.
Yeah.
In Article 120. So in the termination letter, if I mention that you terminated as per Article 120 clause number so and so, it still tells me that I have to pay him end of service benefit. No. If I don't have to pay end of service benefit, do I need to mention Article 139?
You can. I mean,
Because
if you want to terminate someone under Article 120 for a reason in this list. So, for example,
where does it say that?
It says so in the labour law somewhere, clearly.
No, it says in Article 139. So should I mention Article 139
yes,
also?
Absolutely.
So in my termination letter,
yeah.
If I don't need to pay the end of service benefit,
yeah.
Is it important that I have to mention 120 as well as 139?
You can do. The important thing that we like to see in termination letters is the reason for termination. So many times we come across a termination letter and it doesn't set out the reason. You terminate someone, put the reason for the termination. Very often we see letters like, you've been terminated, here are your end of service benefits. But nobody bothers to actually say why you're terminating and under what ground you're terminating. So under Article 120, then set it out. If you terminate someone under Article 120, I would recommend that you've gone through the disciplinary procedure, which is in Article 110 of the Labour Code. So there's a procedure, and it's not an onerous procedure. It's just basically putting forward the allegations to the employee, giving them an opportunity to respond, and then terminating. So many times, employers just get all excited and just terminate without even going through a basic procedure. By giving the employee the opportunity to know the reasons. The employee should know the reasons for the termination before you terminate. So this list is very restrictive in my opinion. I've seen many companies try and use 5, fails to follow basic duties. But you still can't do that if you haven't had the warnings. So you need to have gone through the warning process. So my recommendation to everyone here is really generate as much paperwork. So this is a civil court. There's no oral evidence. So you might come from a country, certainly in the UK, the employment tribunal, you would give oral evidence. Your colleague will give evidence. So everybody's evidence is taken into account. But here in the UAE, it's a civil court. Everything is on the paperwork. So we want papers. If you're going to discipline somebody, we want to see the paper, we want to see records. Did you have a meeting? Where are the minutes? Take witness statement if you have. Generate as much paperwork as you can so that when you do get to the stage where an employee has filed a complaint against the company, you have enough evidence. And normally, where HR has done a really good job in managing a termination, it doesn't tend to go very far past the mediation stage. So you have the Ministry of Labour officials, they will ask, where's the evidence? Because normally you find that they are employee friendly, so make sure you have evidence of all the circumstances. And I always recommend for a company to take some form of advice before doing an Article 120 termination, simply because litigation in the UAE is expensive, it takes a long time, and before you know it, you've spent much more than you would have just paying off the employee. Unless it's really basic, so 7 days continuous service, you haven't come to work, that's quite easy to prove. Well, provided it's genuine, that the employee can show that they were in touch with the company or their manager. So just make sure that the paperwork is all in place before this termination.
Sorry, if we use an employee as a reason for termination,
yeah.
do you as an employer have to prove what